awaits me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you now to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true.
Hey, you guys, how's it going? Happy Friday. Good to see everybody. I tried to do this earlier today, but while Karen Reed was on her, the jury was out doing the tour of the house, and it just angered me so much. And then Karen Reed came back, and there was testimony, so I stopped it. So we're just going to start over from the beginning and hear all of the nonsense. And believe me, there's quite a bit of nonsense. I have not calmed down. I'm still just as irritated, probably more, because I ended up watching some of this to get that quote from the judge. So I'm annoyed. I'm going to be spicy. So if Spicy Jen is not your bag, then you don't want to be here, because this is going to be Spicy Jen. All right. So one of the things that they're going to discuss is this change of venue. Okay. And this is something that the members of the Rhoden family, who are the victims in this situation, are opposed to, because moving it would make it difficult for them to be there at the trial. Okay. And, there are 3 children who have survived. Okay. And they don't have their parents. And so they are being raised by the surviving family members of the Rhoden family, and they have school and all the things. And it's just not feasible for them to move the entire trial. So we're going to get into it. Spicy Jen is on deck. There's probably going to be a lot of pausing. So there it is. All right, here we go.
CR 157, testify versus George Wagner III. The case is set for regularly scheduled appearances. The attorneys of record are still here today, and first issue to deal with is Mr. Wagner's not here, so how does the defense handle this? Mr. Hayes?
Thank you, Mayor. Please support Mark Collins on behalf of Mr. Wagner. Your Honor, we would formally waive his appearance for this hearing. This is kind of a legal hearing with some arguments that are going to be made as well as some procedural aspects. We're very grateful that Mr. Wagner was moved to Pickaway County. We've been able to see him much more frequent because of that. And we've explained that sometimes he might be here, sometimes he might not in general, depending on how many of these status hearings we set. And so he was okay with that concept. So for the record, we would formally waive that. It's my understanding that for whatever reason he has not even been, no one's there to pick him up yet. So, and since everyone's here and ready to go, including the victim's family, we're fine with waiving that at this point in time, not his presence.
Okay, thanks. Is there any position the state has on that?
Whether, obviously, I believe this is the court's decision if they're okay with that. My only trepidation a little bit is that being a death penalty case, although currently the specs have been dismissed, I think in that situation, you don't know that his appearance can be waived. I think he has a right to be here for every hearing, but I would defer to the court on this.
Okay. I would just want to let you stake out your position.
I'm sorry, what?
I wanted you to stake out your position, so you won't have one to speak of.
Deferring to the court.
Yeah. Something else, Mr. Ryan?
No.
So it's a privilege and a right of the defendants to use or waive. I think he fully can. I mean, the circumstances of a death penalty case, like every case, need to be considered.
You guys, the volume is the volume. This is how it was. There is nothing that I can do about it. I cannot make it any louder. The sound booster is on, and I'm so sorry. That's why I'm glad that the closed captionings are available. But let me say something really quick. See if I can do one other thing. Let me try. Yeah, stable volume isn't even on. So there's nothing that I can do about the sound quality. The sound quality is the sound quality. I'm so sorry. All right, let's keep going.
To the fullest extent, so I'm willing to accept the waiver proceeds. We can reconstruct the record if we need. It's how you want to handle it, so I appreciate the fact you want to be productive when it comes down to it, Mr. Collins, Mr. Hayes. So we'll go ahead without it. I sent an email out where I outlined what I thought we needed to do today, and it doesn't necessarily have to be in that order because I didn't bring the email. But there are a lot of issues to go with, so I'm willing to, I guess, tip it off. But there's motions from the victim's perspective. So, Ms. Gall, how do we want to go about those? You have a preference?
Good morning, Your Honor. Maureen Gall on behalf of victim TR and representative TR. I don't have a preference. I think based on the defense's response.
Hang on. Now go.
Based on the defense's response, pointing out that there hasn't been a legal finding of TR as a victim, it probably makes sense to start there. If he's not found to be a victim by this court, then he wouldn't have any rights after that. So that might be the best place to start. And that was the most recent motion that was filed on April 7th, 2025. The designation as motion for designation as victim and request for judicial notice as victim representative.
Is that too fast for me?
Sorry, I can slow down.
Most of us understand that we speak faster than people can write. We don't think about it because it's not our job. I've suggested to the court reporter anytime she needs to stop the whole thing, she will. little overwhelming. But we all do it inadvertently, no big deal. Did you get all that from everybody?
Yes, sir.
Thank you. So there was a response from the defense. We'll just take it in that order. You're welcome to go first with your motion with regard to victim designation.
Okay, Your Honor. Thank you, and may it please the court. So I guess procedurally, it might make sense to go through how we got here. Judge Corbin did issue a decision denying the defendant's change of venue request back in November of 2023.
Were we on victims representation?
Yes, but they raised the issue in their response to change of venue,
I
so
know,
I
but
wasn't
I
sure.
asked you to talk about the victim representation, not change of venue.
Okay.
Thank you.
So the victim definition under Ohio Constitution, Article 1, Section 10 AD, and Revised Code Section 2930-01H is an individual who is directly and proximately harmed by the criminal offense. Victim TR is the brother of a deceased victim. In this case, Chris Rhoden Sr. I do believe that the murder of his sibling does, cause direct and proximate effects and harm on him, both emotionally, psychologically, and then there's the financial aspect. He has, taken the time to drive to and from court, to attend these hearings throughout all of the defendant's cases, but most recently this one, he is here today. He's taking off work in order to be here. These are ongoing effects that are going to continue to affect the way he lives for the rest of his life. There are several courts in Ohio that have upheld the victim definition in a very broad circumstance. They've held that banks are victims. They've held that an Uber driver not identified in an indictment was a victim. They've held that a law firm was a victim. And most recently, the 5th District did uphold a victim definition for parents, siblings, and nephews of a deceased victim. So I would submit that he does meet that legal definition as a victim directly. As far as the victim representative portion of this, there is no law that I'm aware of that requires this court to designate a victim representative. So I would ask the court to take judicial notice that he is acting as a victim representative in this circumstance. I do have some updated victims' rights request forms that I can file with the court where victims in this case have designated him as a victim representative. I think notably it's important that we look to revise code section 2930-02 that allows a victim to exercise their rights with a victim representative or have the victim representative exercise those rights on their behalf. So taking judicial notice that he's acting in that capacity does not dilute any other victim's voice in this process.
Okay, I want you to pay real close attention to that last sentence that she just spoke. She said, yes, he has been designated a victim's representative by the other victims in this situation, but that does not dilute their voices. Okay. So at any time, they can speak for themselves. Okay. I also want you guys to keep in mind that, hey, Justin, good to see you. Hey, Sissy's mom. Hey, Cuff You. Hey, Neat Noodle. Hey, all of you guys. I should have stopped and said individual hellos, but I need to get through this because I'm so angry about this situation. Part of the reason, and we're about to see it, it's coming, he's going to get snarky with her, is because when he began to entertain the possibility of a change of venue, TR, who is Chris Rhoden Sr.'s brother, okay? Anyway, reached out to a victim's advocate. This is an attorney for the state of Ohio, and she works with, like, I don't know, three or four counties. She's going to speak about it in a minute. But anyway, and they wanted to appeal the decision. Okay. But there wasn't an actual decision made. And so that court said, well, wait a minute. A decision hasn't been made. So until a decision has been made, there's nothing to appeal. But he's still salty about that. This Judge Hine, is still salty about that. And it's about to get sideways. And I'm about to get very spicy.
Thank you, Your Honor.
Thank you very much. I'll come back at you, but go ahead, Mr. Hayes.
Your Honor, we leave it up to the court's discretion if TR is a listed victim in the case. We're not taking objection to that at this juncture of time. I think it's within the court's purview and within the court's discretion. We do take into account, and we briefed it, so I don't need to go through everything with this. If they have standing to argue this, and if they have standing to argue against the change of venue, we believe that they do not, and the statute doesn't provide them that standing to do that, so we object on the record based on that. But whether TR is a listed victim, we leave that to the court's discretion. However, we do object to the standing that they would have to argue motions to be part of the proceedings.
Which is why I cut her off early.
I'm sorry?
Which is why I cut her off early when she went the other direction.
Okay. So what's going on right now is, first, TR would have to be recognized as a victim. Okay. That's the first step. The second step would be then to argue whether or not a victim has the standing to be able to speak to a change of venue. Okay. So that's basically what's going on right now.
Back to you, Ms. Cole.
Your Honor, in response to standing, victims do absolutely have standing to assert their rights and to challenge any denial of their rights.
What are their rights?
They have the right to be present, the right to be heard. Those are the two that are most prominent today.
No. You don't get it. The budget. What are their rights?
They have rights under the Ohio Constitution.
I understand.
Article
What are they?
Section 10A. You want me to list all of them? I don't have them in front of me, but they have the right to be present, the right to be heard, the right to restitution, the right to object to unreasonable delay, the right to fairness and respect for their safety, dignity, and privacy. They have the right to an attorney, but not an appointed one, and that's under the revised code section. I think that covers all the rights that I would assert here today. The three that we would be asserting here today are the right to be present, the right to be heard, and the right to dignity and respect for their safety, dignity, and privacy.
Yeah, the right to confer with the attorney for the state. And I
Yes.
brought up previously that the state doesn't represent the victims.
Correct, Your Honor, I would agree.
Essentially, the state's attorney represents the state and talks to the victims, doesn't give them advice, doesn't owe them a duty, right?
Correct.
Now, if there's 10 enumerated rights, you did a fine job checking them off.
Thank you.
But to steal Mr. Hayes' thunder, I don't know that you represent the state any more than the state represents your client, correct?
I do not represent the state. I am not a prosecutor.
All right. Okay. This is real irritating to me because this is not that deep. It's not that difficult. And he's just being a jerk to be a jerk at this point. Okay. This happens all of the time. All right. I'll give you, and I'm not even going to talk about any other cases. I'm going to talk strictly about Ohio, and I'm going to talk about the previous case to this one, which was the state of Ohio versus George Washington Wagner IV, the oldest Wagner boy, okay, or Wagner son, I should say. Now, during that trial, Judge Corbin gave each and every witness the option about how much or how little, if at all, they were to be recorded. They could opt for their face and their audio to be recorded, or they could opt for just their voice to be, just the audio to be recorded, or they could opt out completely and have nothing recorded. All right. Well, he also extended, not only did he extend that to the witnesses that were coming in as lay witnesses and expert witnesses, he also extended that to Angela and Jake Wagner, both of whom opted not to be recorded at all. Okay. Now, he made that ruling and it was appealed. Guess who appealed it? The media. Does the media represent the state? No. Does the media represent the defense? No. Who does the media's attorney represent? The media. That's it. That's all. It happens all the time. At the end of the day, the appellate court upheld Judge Corbin's ruling and allowed them to not be photographed or videoed or any of they upheld Judge Corbin's ruling, and none of their testimony was recorded in any capacity. Let's keep going. Where he's getting this, are you speaking for the state, baloney, is because the state also opposes a change of venue. And let me just be clear. The state of Ohio and the county of Piketon has outlaid a tremendous amount of money thus far. Just in the investigation alone, it was the most expensive investigation in the state of Ohio's history. That's right, you heard me. In the history of ever, this was the most expensive investigation. That doesn't even include the prosecution. To move a trial completely, which means to take the judge, all of the court people that work with the judge, move them to another county and another courthouse, and get another jury from that. It's all expensive. And the county is the one, and the taxpayers are the ones who foot the bill. So Angela Canepa, for multiple reasons, doesn't want a change of venue. The Judge Corbin denied it when Billy Wagner's attorneys initially filed for a change of venue. He denied it for George Wagner. This is poppycock. There's other remedies that don't involve completely moving an entire ass trial, which Judge Hine knows. He just doesn't care. Oh my God, I'm already getting out of control. I can feel it. Here we go.
That was your point, right, Mr. Hayes? Okay. Is this the first request, Ms. Dahl? Like, I didn't read the whole file. In this case, was there a previous request to designate TR as the victim's representative?
No, Your Honor, I only brought that to the court's attention based on the response from the change of venue motion from the defense.
Okay. Like, I only started this last June, so, and you got here after that.
Your Honor, nobody gives a rat's fat kneecap when you started, okay? It wouldn't matter if you started 10 minutes ago, 10 months ago, or 10 years ago. You have made this case a foobar. In the short time that you've been on it, you've messed it completely up.
Yeah, I didn't come in until December, so I'm behind.
Like, in your experience, has there been a deprivation of your client's 10 enumerated rights?
Your Honor, we appealed the change of venue decision from this court based on the argument that they were not heard at that hearing about how a change of venue would impact their right to be present. And the Fourth Appellate District said that the decision we appealed was not final because the venue had not yet been changed, and so they couldn't weigh in on anything else.
Yeah, and they went farther than that, actually, to discuss what you're allowed to participate in, Mr. Hayes' standing argument. I'm just going to want to know if Ms. Canepa is going to cede you the right to talk about her objection to changing venue. So let's put you on the spot.
Why are you doing this? You know very well that that is not what's going on, okay? She represents the victim, in one of the victims in this case. And as such, she has, and the victims have, the right to be heard. Just because Angela Canepa happens to agree with her position does not mean that they are cahooting cahooters or that one speaks for the other. And you know this, man.
Let me know if you consider her now representative for the state to argue the motion that you oppose.
Your Honor, yes. The state's interests align with the victim's interests in this.
Yeah, but that's not the same as ceding representation. So I need to know if she's speaking on your behalf.
Why in the actual F would you even think that she was speaking on the state's behalf? Are you new? What is wrong with you? Is this your first day on the job?
Your Honor, I can answer that.
I didn't ask you. I want her opinion because it's her turn to talk. I know you have an opinion, but I need her position.
I think it's tricky, I guess, because this court has made it very clear that the state does not represent the victim's rights. And while I did make those arguments during the change of venue, some of those arguments, the hardship that this created on the victims and basically operates as an exclusion of them from the hearings because of those hardships, it was our understanding from the court's position that if they wanted to be heard on that matter, they needed to have their own attorney asserting those rights for them. And that's when Ms. Gallup became their attorney, so that she could directly represent their interests. Again, I feel like it's still a state argument, the hardship on the victims, the hardship on the witnesses, all that stuff. So to the extent that her arguments are our arguments, I mean.
That's alignment. I agree that you're aligned on your expectations and goals and philosophy. But mine's a question of representation and whether her speaking is you speaking. Her legal duty to represent a client is your duty to represent a client.
Now, you know that damn right well that you're the one that said that they needed an attorney. They went and got an attorney. And so you set out a hoop. They got through that hoop, and then you set the friggin' hoop on fire. Just playing games.
I mean, she's not appointed as a state's attorney, representing the prosecution of this case. But, again, I mean, she is representing the victim's interest, which we also believe we are supposed to be.
I mean, the truth of the matter is prosecutors confer constantly, all the time. It's in ultimately it's their decision. Okay. But they do talk to the victims. Okay. When it comes to the death penalty, all those things, they do talk to the victims. It doesn't mean that this is just, he's just being like deliberately obtuse. And I really wish, and I'm a little bit disappointed. I got to say, I haven't seen it yet. So let me reserve disappointment, but I really hope that the law tubes community weighs in on this, because I would really love to know what they make of this.
Sorry. So, I know I'm not answering the question.
Yeah, and I'm not sure if it's a lack of knowledge or inconvenient because it's a huge deal with regard to who represents whom. Like, I don't want to hear a lawyer speak for some other party because they can't. The way you can't represent the victims, in my opinion, is the way the victim's attorney can't speak for the state. I have to look at one table and realize there's different clients.
I'm gonna rewind that, but I want to answer Cuff You, because before we listen to him talk about the seating arrangements at the fucking Thanksgiving table, I need a moment, and I'm gonna answer Cuff You. So Cuff You says, I mean, am I stupid or the prosecution not care about the victim's right, and so now the victims have gotten an advocate, and this judge has a problem with that? No, you're not. The judge has a problem with this. But that's not quite how it went. when this issue of change of venue first came up before Judge Hine, Angela Canepa, who's the blonde standing right now for the prosecution, listed victims. It would have been it would be a hardship on the victim's family as part of her argument for saying that there doesn't need to be a change of venue. It's part of it. It wasn't the whole argument like he's trying to make it out to be, but nevertheless, what he said is the state does not represent the victims. So the state should not be speaking for the victims. All right. So then the victim said, oh, okay. If Angela Canepa cannot speak for us, we, through the victim's advocate portion of law enforcement, you know, everybody, they have victims advocates, set them up with one of the 3 attorneys in the state who does this type of work. And TR, who is the victim in question, they signed an engagement letter, and now this attorney represents TR, just like the judge said. So he made a hoop. They said, okay. They went through that hoop, jumped through the hoop, and then he's like, no. I know you just jumped through that hoop, but no, you're gonna have to go back to the starting line. And then he set the hoop on fire, and that's what's going on right now. Oh, gotcha, cuff you. My bad. Okay, let's keep going.
I do it all the time, so do you.
Hold on, we're rewinding it.
Yeah, and I'm not sure if it's a lack of knowledge or inconvenient, because it's a huge deal with regard to who represents whom. Like, I don't want to hear a lawyer speak for some other party, because they can't. The way you can't represent the victims, in my opinion, is the way the victim's attorney can't speak for the state. I have to look at one table and realize there's different clients. I do it all the time, so do you, with regard to multiple defendants in trials simultaneously, right?
Sure.
It's a big deal, and we can't blur this line. She's going to want to speak on reconsideration of a motion. And I got to decide if I'm hearing you when her mouth moves legally.
See, this is ridiculous. He knows damn right well that he's not hearing Angela Canepa, but the victims do have a right to be heard in this matter, and that's it, that's all, and that's all they're asking. Hey, listen, Your Honor, this is why, as the victims, we oppose the change of venue. They know that the judge is going to do whatever the heck he wants to do anyway. It's called judicial discretion. They all have it.
Well, I do intend to provide supportive arguments in this matter.
Yeah, but now we're back to the waffling. Go ahead. It's a first of all, like, there's a lot of discussion in the judiciary about the new rights that are co-equal to the defendants because of the Constitution. We're all getting used to a law that we thought we knew, but we're watching it being expanded and contracted and explained. I put in my routine regularly now that the state doesn't speak for the victim, nor give them advice. And if they have the wrong impression, it's their wrong impression. There's no legal duty. No victim's allowed to sue the prosecutor for bad advice.
Right. No, I mean, obviously Ms. Gow represents the victims in this case. I mean, that is
Period. Only.
period.
It's a big period. It's a big only. Right? Would you agree?
I believe so, yes, because there may be times where her position is different than the state's.
Okay, I don't think this is hard, but it'll get hard when we start applying concepts.
No, bro, you're making it hard. You're being deliberately obtuse just because you can. I don't know what happened. I don't know what's going on. I don't know who hurt you in a past life, this life. I don't know what your problem is. I don't really know what your damage is, Heather. That's what I feel like. God, what's your damage, Heather? What is his problem? Like, who whizzed in your Wheaties this morning, bro? This isn't hard. These family members, since 2018, have come to every single hearing, every one of them. Fucking dick.
Yeah, and again, and that's what I was talking about, kind of that trick bet, because while I would be happy to carry the torch for the victims, this court has made it clear that I cannot. But in order for them to,
No, the law makes it clear. I'm just
Okay.
delivering the law.
okay.
It's
you're
not a
delivering the
discretionary item. It's a huge deal.
message. Okay,
Because I get abuse of discretion thrown at me when in fact I'm just speaking what the law requires me to say.
yeah. But then,
No. No. You back that train right the fuck up, sir. You did use abuse of your discretion in your sentencing. You know you did. I know you did. The court, everybody knows you did, except for you just want to act like you didn't. We were all there. We heard what you said. You gave a guy who slaughtered an entire family, and then, as if that wasn't bad enough, took Hannah Mae Rhoden's newborn and put that baby in the bed with his dead mother so that the baby could breastfeed. He's a sick twist, and you gave that rat bastard a fucking chance at parole. That's what you did. That's abuse of discretion. And then, as if that was not bad enough, you blamed Angela Wagner for not stopping all of it. Look, Angela Wagner ain't no peach, okay? Lord knows that woman sits at the right hand of Satan, okay? But Jake was culpable. Jake is the only one who benefited from this. It was Jake's daughter that the custody issue was regarding. You son of a bitch, man.
in order for the victims to be heard and there to be any real meaning to that requirement, they have an attorney and she needs to be heard.
And as far as I know, I've got to ask her again, she's had that opportunity. Like I try to acknowledge her every time she's gotten here and invited her to sit in the front when she chose to sit in the back. So there wouldn't be the impression it's a lesser relationship. Like, am I supposed to have a seat at the table for the victim representative, Ms. Gull, moving forward the same way the state has their representative right behind them? I'm like totally willing to accommodate that. But like people have to talk to me about their expectation of their rights, because if he's designated the victim representative, do I pull another table? Do I offer you another table when you get the choice? Like I'm not trying to step on anybody's rights. I'm trying to get it right. But you have to talk to me about what you think's going on, and then I have to decide if it's the right application of the law. Okay? So like run it through your list of things and understand is, do you want your victim representative who's sitting at counsel table or not, if I designate them that? Go.
You want me to take
Yeah,
that?
go ahead.
No, Your Honor, that's not something that I'm asking, and I don't think that's something that victim TR wants. I think he wants to sit with the
Yeah,
family.
thanks, that helps me. But if in 4 months you came back and I never asked and you didn't request it, I get second guessed.
Your Honor, not by me in that circumstance. I would like to make a clear record on who I represent, though. I don't represent the state's interests. I have I didn't in my motion, my written motion, and I won't here today make arguments for the state. My sole purpose as the legal representative for victim TR is to make sure that his voice is heard, and the effects of a change of venue would implicate his right to be present at trial. There are hardships that the entire surviving family
equally unfair is for somebody sitting at council table to impute to the court knowledge of something that was never raised. And that's why I asked specifically, has there been an occasion where the court inadvertently or intentionally violated any of your rights, any of your client's rights, any victim's rights? Like, I want to know about it so I can not do it again, because nobody said anything, so therefore silence is acquiescence until the second guessing shows up. Like, it happens all the time. I don't find fault with it, but if it's judicial second guessing, like, I don't want to get hung with that again, ever. I want to learn. So that's the segue then, is if I designate a victim representative and we have an opportunity for a representative to speak, who do I ask to speak? The victim representative, or anybody who's related and is a victim. Like, did I just lessen rights by designating a victim representative? Because I said there's one victim and the other 5 people that have a right to speak, in my opinion, now don't. So you want to chew on that since you did the segue? You
Yes,
want
Your
other
Honor.
people to speak, right?
Yeah, so the law says that a victim can exercise their rights on their own or with a victim representative. So the law supports that all 5 of those victims in your hypothetical situation would be able to speak.
Yeah, I'm going to give that. I'm going to
Okay.
give them that. Let's understand, I'm not trying to limit your rights.
Okay.
But I don't want you to inadvertently tie my hands by designating, asking me to designate, right? And then all of a sudden you find out that you closed the door that I didn't think should have been closed, and I'm stuck with it. So I don't intend to limit anybody's rights. At the sentencing hearings, people spoke their minds forcefully and appropriately, right? Like, we're going to do that as long as it's appropriate. I just don't want you to inadvertently limit what I think is appropriate.
Yes, Your Honor.
Okay?
The
Yeah.
victim's rights request form allows victims to designate a victim representative, and so and that victim representative can receive notice on behalf of them.
Talking about this.
Yeah,
Right.
so that would be my argument submitted, is that even if this court did take judicial notice as that TR is acting as a victim representative, that doesn't tie anyone's hands as far as the rights that other victims can exercise with him or on their own.
Okay. Also, I'd like you guys to keep in mind that when the judge first took over this case, one of his pontifications up there from the stand was that he wanted to streamline this and get it going. That it had been far too long, that Billy Wagner had been sitting in jail since 2018. It's now 2024 when he took the case. And so he wanted to move things along in a more streamlined and expedient fashion. This is the most pedantic argument that he has made yet, and a clear waste of time. All they asked was to be heard. He wanted them to have their own separate representation. That's what they did. And now we're arguing for what again? Nothing, because he's just being a jerk.
The problem with forms is they imply things they don't mean to imply. Because here they list a victim, singular, and then below it they say victim representative, which I think means an advocate or a lawyer. Like, I'm not intending to limit anybody's rights, but if the defense hears a lot of things that they think are damaging and wants me to say they don't qualify as a victim, then I got to get my hands wrapped around what you asked for and whether they're right. I don't have this form. You have a victim rep. They get one very damaging statement, not 5 or 15, right? Like, I don't tend to be narrow in my application of victims' rights. But if you close and tie my hands, then that's on you, not on me. Like the whole concept of invited error.
Yeah.
Still.
Strategy, right?
No, it's not strategy rights, it's substantive rights.
Okay.
It's because you represent TR, right?
Yes.
Well, what about all those other people? Do you represent them?
I don't have an engagement letter with each victim in this case now.
See where this goes? Like,
But
who's
No.
the
he is
victim?
just, that's why I'm asking that this court take judicial notice that he is representing the interest of
I think
many
so.
victims. I think all of the victims in this case are in alignment with, moving this case forward and hopefully achieving justice, I think is.
But if they're not aligned, how many victims, lawyers do I get? 5, if there's 5 victims?
Well, I only
9?
know of 3 in the whole state, so I don't know if you get 5 or not, we have to find some more.
I'm not finding them, but they have the right to get their own.
Right,
Right?
yes,
Alignment's a really cool thing until it's not.
correct.
So,
I think as long as they are
hold on, ma'am. So, what are you asking here, Judge Hine? Are you asking this attorney to see into the future, to the possibility that the family may not align with what TR wants? Is that what you're asking? Are you asking this attorney to crystal ball some shit that they can't possibly know in the future because you're worried that you're going to get in trouble down the line? Let me just explain something to you. If you get in trouble for anything, it's going to be this bullshit right here. Not listening to the victims. Jackass. Oh, he makes me so angry.
in alignment, a victim representative can voice that alignment and that interest on behalf of many individuals that are unable to attend each and every hearing for whatever reason, whether it be health, school obligations with the orphaned children, and I don't want to get into an argument.
No, this is a healthy discussion. Like,
Okay.
this isn't argument.
Okay.
It's argument, but it's not argumentative.
Right.
I
That's
let
what
Miss
I meant.
Canepa, I let Miss Canepa come at me.
Okay.
And some people thought it was like disrespectful, when in fact I found it engaging. Like, she raised her voice, but I wasn't offended because it was a heated, passionate issue. Like, would I let her do that again? Yeah, as long as she was professional and like engaged, didn't take it to a personal level, and she didn't. Like, that's that's what we do in this room, right? If you don't have like a firm conviction in your position, just get out. Just don't demean the judge or the system or take it personal, and we'll all get along fine.
We're all on the same page.
Wait till you have to tell one of the family members that you can't listen to them because it's not consistent with your client's position. And good luck figuring out what to do.
Why would,
Ms. Canepa,
are you high? Why would that happen in this situation? Do you understand why she was retained in the first place? She was retained because you requested that Angela Canepa not speak for the victims. That's it. That's all. That's why she was retained. The issue, and there was a whole ass other trial, mind you. Did you look at that? The victims didn't have an issue in that trial at all. They're just asking that you don't move the trial so that they can attend. What is so hard about that? Why are you overcomplicating this? What is your problem, bud?
Mr. O'Brien faces that risk all the time when they have to figure out who they listen to when they're just giving information, right? Been there, done that. I got this t-shirt. I got the scars on my back when the victims turn on the prosecutor. We just sort it out. Like, if anybody says easy today, they don't understand what we're doing. Okay, do you have anything else on the victim representative issue?
No, Your Honor, I don't believe so. Not at
On that issue, like, I'm gonna give you a chance.
not on that. Yeah, not on that point.
Mr. Hayes, you want to, like, jump in here? You don't have to, but
Judge, just reiterate our previous points. I believe they're a party to the action. I mean, the victims have a right to be present in the courtroom. Nothing that this court ever ruled, and the ruling on November 25th, they released that. Nobody's ever barred them from the courtroom. They have a right to be present. That right is always been for the victims.
yeah, thank you. I appreciate your position. Ms. Canepa and Mr. O'Brien, like, I haven't asked you if you want to make a record talk on the thing.
On the victim.
Yeah, like on this last discussion we had, this call.
Representation, yeah, and it's my understanding, I don't know if Ms. Dow brought this out, I think she may have, but there are a number of other victims present who have signed a form saying that they want TR to be their victim representative. So, you know, to our knowledge at this point, there's no victim that is not in favor of him being the kind of spokesman. So yes, and I would say, you know, the court's decision certainly substantially impairs the victim's rights, we believe. And so we would believe they do have standing at this time to at least present considerations for the court.
So the decision on designating a victim's representative is deferred pending today, so I'll get you a decision. I'm not just going to announce from the bench. Like, I hope you did hear me say I'm not interested in limiting victims' rights and don't want to do so inadvertently.
Okay. Yeah, we heard the words that came out of your mouth. Okay. None of the words that came out of your mouth are, here's a word for you that you just love, are aligned with that meaning. Because you're playing games. That's what you're doing. And it's just about to get worse. Oh, I'm so irritated with you.
Okay?
Can I just add one thing, Your Honor? Just per the law, and defense didn't offer any, I don't think this court has to interpret any law, and they can just take judicial notice that he is acting as a victim representative. As far as the victim definition of TR, though, that is a legal finding that this court would need to make, and it would implicate whether or not we have any rights when it comes to the change of venue. So I'm not sure whether the court plans to hear or determine standing at this point in time.
I'm going to let you explain how victims' rights articulated in the Constitution crash into the change of venues rules. I'm going to let you argue that.
Okay.
I'm not going to concede that you have the right to. That's the standing defense put up, right?
Correct.
And if I find you don't have standing, I just ignore everything you said, necessarily. But if I don't hear it, I don't know what I'm doing wrong, right? Like, there was a pretty good argument with regard to, not agreement, oral argument with regard to whether change of venue is appropriate or not. I wrote a decision. Everybody's welcome to like it or not like it. It's not the job. But then I apparently didn't hear enough of your perspective. So I'm going to hear some more of your perspective, which does not imply anything other than I want to hear. There's a motion, but it doesn't necessarily imply that you have standing. Just want to know what I don't know. Make sense?
Yes, Your Honor.
Have at it.
Okay. So just procedurally, I think it makes sense to make a clear record of how we got here. In November of 2023, Judge Corbin issued a decision denying the defendant's change of venue request without prejudice. In September of 2024, the defense filed an amended motion for change of venue before this court after Judge Corbin had retired.
do you want to put evidence on, or just your argument proper?
So I do not have one of the victims that would like to be heard here today due to school obligations with the orphaned children. So I have 3 statements that I would like to read into the record and submit as exhibits. I did notify the defense of that. I'm not sure whether there will be an objection or not.
Good to know. What do you think, Mr. Hayes?
Judge, one, I'm not sure who these letters have been from, if they're from TR or from some other parties. We've never seen the letters, never been provided the letters. Just briefly before the hearing today, indicated she had some letters, wondered what our position is. So at this point in time, we would object.
So you want to recess?
Yeah.
Okay. Do you have copies that you might be able to show?
I do, Your Honor. I have 8 copies of each for the court and defense and state.
So are they like marked with numbers?
Not as of now. I can identify them as exhibits if the court would like.
Well, I don't like to. I have to. If you're getting ready to introduce to the record something the court reporter needs to be able to identify, so call them victim 1, 2, 3 or victim ABC or whatever it is you want. Put a date below it.
They are each dated as letters, April 25th, 2025, but I can write the date on here too.
That'll work.
Okay.
There it was. Did you see it? There it was. We're going to rewind it again 5 seconds, and I'm going to slow it down.
April 25th, 2025, but I can write.
Now he's rolling his eyes. Let me just slow it down a little bit. Pay very close attention because it's quick.
The date on here too.
That'll work.
Did y'all see that? You want me to do it again? Because I would love to know who it is that he is winking at. Let's watch that again. So inappropriate. Who's he winking at, y'all? Disgusting. This is just an absolute travesty of justice. I don't understand how he even... I don't know what they can do to get him off the bench, but my God.
Would you like some stickers?
Sure.
So let's take a recess, standing break. Don't run away off the record.
Thanks, Your Honor.
At first, I thought maybe he's winking at somebody here in the audience, but who? Who the heck would he be winking at?
Yeah, but arguably you could say I'm not supposed to have those. No, get it?
Am I supposed to have it yet?
We're going to
Put it down there, okay? 'Cause that's the record. No, I don't want to like. A minute break to organize the documents, so Ms. Gall, you're on the record, go ahead.
Your Honor, we've already addressed standing. You said you would make a decision. So moving on to change of venue, the victims have the right to be present and heard any time there's a public proceeding and any time their rights are implicated. With relation to the criminal offense, their rights are absolutely implicated by a change of venue. We are,
Which right is implicated?
their right to be present. It's substantially impeded by a change of venue, specifically based on distance. We are not aware of what county this court is changing the venue to. And so had they addressed the court back in October,
whether you drive to Waverly or whether you drive to Hamilton, is it not the same implication? It's an inconvenience to have to come to downtown Waverly if you live in the northwest corner of Pike County.
Absolutely, it is, Your Honor.
Okay, so
but-
how do I sort out when the rights are violated? Does like just geography, and I can take 25 miles is reasonable, and anything over is there an objective standard?
Your Honor, I think the right here is the right to be heard. Victims have a voice in the process, and these three statements explain what the effect would be of a change of venue, which is why I asked to proffer those in as exhibits. TR is here and willing to take the stand if you'd like me to direct examine him on the effects that this would have on him specifically. I wasn't going to do that. I was going to let the statement speak for itself. But he specifically speaks for his mother, who's also an 82-year-old elderly woman with health issues. And so, yeah, moving this out of Pike County would just be unfeasible. And it doesn't offer an opportunity for them to exercise the right to be present.
So does the defense have, first of all, you had a chance to look at the three exhibits, right?
Yes.
Okay, so do you have a position, Mr. Hayes, with regard to the court being made privy to the contents of the material as evidentiary matters?
As an evidentiary matter, no. I think the court can take it into consideration for whatever way the court deems appropriate.
It doesn't cash in or concede the standing issue, like I said.
Correct.
I want to state the obvious.
Correct. Just like a bond hearing, the court can take in other factors and other issues, so no objection based on that.
So I'll consider the substance. I'm never going to tell who to call. Never's not fair. I rarely call my own witnesses. So if you have witnesses, then you're welcome to call them. I'm not telling you to call them.
Yes, Your Honor.
I'll take the letters, though.
Prefer not to. I would move to admit exhibits V1, V2, and V3. I can also read them into the record.
No, just give me the three, because Mr. Hayes has conceded that I can consider the substance. It doesn't concede the standing, so,
Madam President.
yeah, thanks. Assuming, of course, you think that the letters don't violate the client's rights.
No, Your Honor, the letters do not violate the client's rights. It offers them a voice in the matter, and I do concede with the defense that it's the judge's discretion, it's the court's discretion to weigh this matter, and all of the evidence presented. Again, I want to clarify that what I represent is the victim's interest and their voice in this process. They did not address the court in November, and that's why we're asking for a reconsideration of the court's decision. They do, in the Constitution, it says that their rights should be protected in a manner no less vigorous than the defendants. Defendants have to waive their right to be present at trial, whether that's in writing or on the record orally. Here, there's been a lot of choice and choose wording in both the defendant's arguments and in their written brief response. And, I would proffer to this court that there is no choice. If this moves outside of this county, that takes away their choice. Like I said, there are children involved.
Do you now understand why I will not let you not appear? You said you were entering a limited appearance, but you wouldn't go to trial, and I refused that. So you have to show up. Do you understand why?
Your Honor, I don't know that this court has the
Oh,
authority.
no, I
to
totally do.
decline
You entered an
notice,
appearance.
and
I'll stop talking when I'm talking. With all due respect, you don't get the option to not show up, because everything you're talking about that's so important has to be represented in the moment, not after the fact. If anything,
First of all, put your finger down. That is rude and disrespectful. Let's start there. I'm not 100% in love with your tone. All right? That's the second thing. The third thing is she's telling you that they don't have an issue with the way that the prosecution intends to present this case. There's nothing they can do about the defense. All they care about is being able to come to the friggin' trial. That's all they want you to hear them on. What is so difficult for you to wrap your brain around? I have a freaking GED, a good enough diploma, and I understand what is going on here. I'm not an attorney. And now you're going to force this civil worker to be present every single day for a month at the trial because you're upset that after a ruling that you made, that the victim did what you said the victim needed to do, that the victim needed to first be designated as a victim representative. That was the first thing. That the only way that you would allow the victim to be heard is if the victim had representation. That's what she's doing here. That was number 2. Check and check. And now you're just creating an additional chaos and havoc for what? Because you want to sit and argue? Then get off the bench and go back to being an attorney.
I made a decision without you here that you later complained about. And I didn't even know was going to be the grounds for a complaint. So understand, it's in the record, now it's from my mouth, that you don't have the option to not show up. Every call of the court means you're here, period. I'm going to remind you that I have the authority to make your life very difficult for not honoring that order. Because this is too important for you to opt in and opt out, to say when you think you're needed and when you're not needed, because these are big issues in my world that can't go unanswered at the moment. So if you're
Are you going to be answering questions of venue during the trial, Judge Hine? Is that what you're going to be doing? Or, I mean, is this trial going to be some kind of bootleg version of what's the chair game? Hot chairs, hot seat. What is it called? Musical chairs. Is that what we're going to play here? Each week, it's going to be a different venue. And you're going to want to hear from the victims about how they feel about the venue. So what? You can just ignore it? Shut up. Just shut up.
not here, you have a problem. Because this is so important, you don't get to opt in, opt out at your choice. Got it? There's nobody in this room has an option as a lawyer to show up or not.
Your Honor, respectfully, I disagree. I think that
Okay.
the decision that the contract that I signed with my client is for limited appearances.
That's fine.
We have
That's
3
needed.
attorneys for the entire state. We don't have any funding for me to sit in a month-long trial. I cover 13 plus counties for the state, so that's just unfeasible. I also have a family in Cincinnati, so.
It's a really good record to make. It's a really good record to make.
Yeah.
All of which I can't care about. Because what you just said applies to every other lawyer in the room. And me. At some point in time, our duty to the profession and to our clients exceeds our personal convenience and our staffing.
Not my family, no, Your Honor.
Okay, I get it. Good luck with work-life balance.
My client can waive my appearance, and he has. He agreed in that contract, and that was what the limited notice of appearance was filed for. My client has the right to do that. Me and my client have the right to contract my availability, but I think we're getting off track. I don't know that that's.
No. We're right on track. First of all, I'll tell you what I want to talk about, and then we'll stay on my track. And I respect your desire to have work-life balance, but the law is a jealous master. And we're going to get this right, because you showed up after the fact and complained about things I didn't do when you weren't here, and the whole...
Why are you taking this personally? She didn't show up after the fact and complain about what you did. She was retained after the fact because of something that you said the victims needed to do. Once again, The common denominator in this situation and this problem as you see it is fucking you. You are the problem, Judge Hine. You.
Whole second guessing can't happen moving forward. I'm giving you the privilege to ask me to reconsider a decision I already made. It's a privilege to hear it because I want you to advocate. But you can't advocate after the fact again. I don't know where you live and have a clue about children and family. I'm happy for you. But work-life balance is like a mirage. It's totally mirage. Now you have to go talk to your management. But I brought this up and it's on my list to make it really clear. Like Mr. Collins not being here without explanation for trial, he knows better. He 100% knows better. Like if you want to have a limited representation agreement with your client, that's between you and your client. I got nothing in that because I don't represent the interest of your client, you do.
Right.
And I'm not going to have second guessing after the fact with you gone. You're on record. If you want to withdraw and your client wants to sign off, then that's a different deal. But a limited representation is not happening on this case in this instance.
So, what are you saying? The only way that you're not going to hold her to be in court every single day of the trial is if her client signs off and withdraws his request for reconsideration of change of venue. Is that what I'm hearing here? Because to me, that sounds a little blackmaily.
So I'm just going to tell you that I already ordered your appearance all the way through. Figure it out. We're not going to trial next week because we're stuck in the Court of Appeals. But when the case goes forward, the more lawyers, the better.
Your Honor, I'm going to assume that my client's going to have standing then, at this point.
Oh, no, they don't have to have standing to be a
I'm not
victim.
sure I would represent their interests in this case. If they don't have standing, then I can't be heard anyway.
There you go, sister. Tell him. If you're not going to recognize that my client is a victim and therefore, because my client is a victim, my client has standing to be heard, then how are you going to require me to be in attendance in every single day of the trial for a victim that you don't recognize as a victim? Good for you. Tell it.
So I guess I'm still waiting on a decision on standing prior to trial.
So if I say there's no standing for you to argue on behalf of the state, you're saying your client's no longer a victim?
I don't want standing to argue on behalf of the state. I want standing to assert my client's rights and any denial of those rights, which is the right to be heard when it comes to a change of venue that implicates their right to be present at the trial.
Okay, let's go back and let you finish now on the merits.
Okay. So they have the right to be present. I don't know that there's any indication or objection that they do, but that comes from both the constitutional amendment and the revised code. And all appellate districts and the Supreme Court that have taken up the issue of a victim's right to be present for the entirety of trial have issued in favor of victims being present. I was on the argument of their rights to be protected in a manner no less vigorously than the accused. Criminal Rule 43 requires that waiver from the defense. And, victims also have a right to be present for the entirety of trial, so they're the only person that should be able to waive that presence. And, the letters that you're going to take into consideration show the
There has got to be something that we can do. I think the judge, I don't know what the judge is going to do in this case. I have a strong suspicion that he's likely going to say, too bad, so sad, I'm moving it. There's got to be something that we as human beings can do to help these other human beings so that they can get to the trial at least maybe twice a week. I'm going to look into it. I cannot sit by and let this just happen where these family members can't go to the trial, especially Chris Rhoden Sr.'s mom.
So do I ask your clients for financial disclosure and affidavits of contingency? If I'm supposed to be exercising
Deborah, this was today. This happened today, this morning.
parity, competing victims' rights weighed in the same manner as defendants' rights, do I not regularly ask defendants about their ability to afford a lawyer and make them fill out financial disclosure forms before I just make sure they have adequate representation? I mean, it's a hypothetical question, but like you just made a very important fundamental argument that's just proof with facts, void of anything other than conclusion. So do I make like TR, give me a financial disclosure form, list his assets and his liabilities, and I go through some comparison to federal income guidelines for a number of people in his household, the same way I would for a defendant?
Your Honor, I think we're comparing apples to oranges there. One, victims aren't parties to the case, and two, they don't have a right to.
But they're not a party, they don't have any right to argue a motion.
They do, under the Ohio Constitution and Revised Code section. They do have rights within the criminal proceedings, but they're not parties to the case. So they have privacy protections still.
Where's the privacy protection?
In Ohio Constitution, Article 1, Section 10. I don't have it off the top of my head, but they have a right to privacy in both the Revised Code section and under Criminal Rule 17C. Any subpoena would have an opportunity for a motion to quash, and then if the whole Nixon test hearing, etc. They do have a constitutional right to privacy, though.
Why don't you like send everybody an email, including me, with you articulating the authority for that? Like I'll take your word for it, but maybe that's not a good thing to do. I'm not really sure what I'm supposed to believe when people talk. No, proper is one thing, but like you just made a fundamental argument that was conclusory. So I got to flesh this out.
Are you really going to sit there on that bench and act like you think that asking to see the financial statements of a victim doesn't violate the victim's rights to privacy? Are you seriously going to sit there and act like you don't know whether or not you are allowed to do that? You have got to be absolutely kidding me, Judge. Deborah says, I live a county away. This case is rarely talked about. Has that always been the case? Like when it was closer in time to the actual events, like say between 2016 when the murders occurred and 2018 when they got arrested, did they talk about it then? Because I'm very curious. If people are very rarely talking about it, living a county away from you, then one thing the judge could do would be to send out some jury summonses to the people in your county, for example, instead of, moving the whole entire trial. He has that. He can do that.
I don't ever ask a victim for financial disclosure.
Right.
But you just asserted economic hardship. And Mr. Hayes might not like the fact that I just assumed a fact that's not an issue. He might be fine with it. But I wouldn't ever let a defendant get a lawyer without signing a income affidavit saying you can't afford one.
Your Honor, I think this court has discretion to consider any hardship on the victims when it comes to implicating their right to be present in trial. I think the weight that you give that is, again, up to the court's discretion.
Keep going, thanks.
That's, I believe all I have at this point is that I just don't believe that there is any choice in this matter. The further this case moves away, the less likely there is any ability for these victims to show up daily, and they did in the co-defendant's trial. Even if those were half days and then they reported to work afterwards, they were able to be present. That makes a huge impact on the jury to see whether victims are in the courtroom. It also, with the live streaming, it assumes that not only the courtroom that this trial will be held in has strong internet accessibility and signal and all of the equipment necessary, but also assumes that each and every victim that would like to attend via live streaming has a smartphone, a tablet, a laptop, and also strong internet connection.
But if they didn't have transportation to the courthouse in downtown Waverly, is the court then supposed to send out an Uber driver?
No,
Or
Your Honor,
Lyft? What's the difference between, I gotta consider whether you have a valid driver's license and a car, as opposed to I have to consider whether they have a tablet and internet service? I get what you're saying. I'm just trying to understand the scope. Like, you're supposed to be the expert in victims advocacy, so I get the benefit of going to school on you. So if I'm supposed to consider their internet accessibility, is that any different than me having to hear an argument next month that somebody doesn't have a driver's license and the court owes them the legal obligation to send out a chauffeur driver every day?
No, Your Honor. Again, I think that's apples and oranges. This court made a determination that live streaming was sufficient to uphold their rights. You then instructed us to file on the briefing schedule to be heard on the issue, and I'm telling you that these are general concerns based on the decision that was made specifically. No victim is asking this court to afford them an Uber. Again, they're not a party to the case, and they don't even have the right to appointed counsel, so I don't think this court has any financial obligation to them, but it does have a legal obligation to uphold their constitutional and statutory rights. And so that's where that right to be heard comes in. And I think, again, there's a difference between a victim being expected to assert their rights in the county where the crime was committed, and again, that choice was made by the defendants, not the victim. The victim doesn't have any choice in participating in this criminal justice system. They didn't choose for these crimes to happen in Pike County. The defendant chose for the crimes to happen in Pike County, and therefore the defendant should answer to a jury of his peers in Pike County if that is a possibility.
Well, I'm a former crafty prosecutor, and Ms. Canepa could have picked a different county. So in fact, the state picked the venue based upon the facts available and did a logical, fine job of it. It's not just like because an element happened here, you have to have it. She could have picked a different venue. We're dealing with the fact that that's her judgment. And it's her judgment. So, like, if there's heartburn about location, maybe it's just systemic.
Your Honor, I think generally speaking, the crime is usually tried in the county where the crime was committed.
Yeah, but one of these crimes was committed in Scioto. So what are we doing in Pike? Her judgment, logical,
Yes.
educated, wise judgment. But her judgment nonetheless.
And I think the argument there would be that Scioto County is about 30 minutes away, and Cuyahoga County is not. So I think a big part of this is unknown how big of a hardship there will be until the actual venue is disclosed. But I think the point of this hearing today is to make sure that the victims are able to express the hardship that HH venue would have on them, and if you take that into consideration and believe, that the venue should be Scioto County,
But this is a fascinating argument because a whole lot of people want to know how this plays out. It's less inconvenience and equal participation, in my perspective, when I live stream everything that happens in downtown Waverly to your house. So you can do childcare in your house without a car, and my accommodation, in fact, gave less inconvenience to the public and victims in particular. So now it's a question of perspective as much as anything else. And I live streamed for years.
Your Honor, in perspective to that, though, Jake and Angela, who are the key witnesses, and were in George Ford's trial, declined to be recorded and videotaped. So there was a whole week of testimony that if the victims hadn't been here in person, would not have seen. And I think that's major. That's a huge consideration to make when it comes
For
to live
the
streaming
jury.
and the convenience of it. I don't know that there is convenience if they're still missing out on the main witnesses testifying.
Like, I'm just trying to tell you that there's easier ways to do it than being there. Like, I've conducted remote trials where no witnesses are here, and half the lawyers are. And everybody agreed that that was more convenient and more accessible than thinking you have to be in a physical space designated courtroom.
Your Honor, I don't disagree, and I think, live streaming and everything that came out of COVID and all the remote appearances and stuff are a double-edged sword because a huge part of the defense's argument is the publicity of this case, and that's why it needs to be changed. But if we're arguing that everybody has access to internet and Peacock and Google, then I don't know what a change of venue does in this particular circumstance either.
How about this? Your dilemma is my dilemma. You're going to be wherever I am for the length of the trial. Unless, of course, I allow you to participate remotely and give you a live stream to your house in Cincinnati. So which one's the harm?
It depends upon the individual, and that's why the victim submitted
So it's the
statements.
victim's decision?
No, Your Honor, if the victim's voices should be considered.
Yeah,
It's
like
not, they have a voice, not a veto. I would never say that victims' rights are, elite to the U.S. Constitution. I don't think I would have any credibility.
Well,
if
go with the
any
Ohio
court said
Constitution
that.
because that's what we're talking about. Ohio constitutional rights for a defendant stacked up against Ohio constitutional rights for a victim.
That's a discretional weighing that this court has
I'll try
to
not to screw that up
consider.
again, if in fact you think I did the first time.
Your Honor, I wasn't here. I was just,
Which is the point I already made.
yeah.
So, like, maybe I'll accommodate you and let you participate remotely, assuming you can waive that right.
Your
I'm
Honor, these
very
are
serious.
all questions that I don't have an answer to today, and I think depend on a lot of different circumstances.
Major understatement. You're right. Okay, so let's flip the switch. Mr. Hayes.
Judge, nobody's arguing that the victims don't have a right to be present. The victims can be present in the courtroom, the court doors aren't going to be shut. There's live streaming, the state can help facilitate some options in transportation if they needed to, but nobody's advocating that the victims don't have a right to be present. They do have a right to be present. In order for the victim to have standing, they must point to a specific right that has been violated. There's been no right that's been violated in this case. If this case proceeded federally, it would be tried in Columbus. You have jurors that have to be transported or find transportation from Ironton, from Portsmouth, come up for jury duty, and witnesses that have to come up there. These happen all the time. This advocate cited State v. and I'm going to spell this, Timmendequus. It's a New Jersey case, 737 AD 55. That case has no precedential value in Ohio. It involves a New Jersey statute. That statute constructed is broader than what was provided under the Ohio Constitution. It also discusses inconveniences to witnesses, inconveniences to that is broader than what is in Ohio statute. But at no point does the listed victims have the right to choose where the venue is, to choose where this case is going to be tried. We discussed, and I don't think I need to go through everything that was founded in this court's November ruling. The homicides that occurred in Pike County touched the heart and fabric of this community. It touched everybody. It's a small community. We've argued that. And if there is any example, any circumstances in Ohio, I've been practicing over 30 years, Mr. Collins has practiced longer than that. I can't think of where there would be another example for a change of venue in this case. And especially, this isn't the first trial. This would be the second trial in this county. But we've argued that, we discussed that, we talked about the saturation of the market and the individuals here. In reality, you know, if we started to do a trial here, would we try to push through it? Is that going to, you know, give us the right to a fair trial at that point in time? Then we have to step back and then reschedule and reevaluate our schedules and our dockets, and it would just be, you know, extremely difficult to do. There's no way we can have a fair trial here in Pike County, you know. So I ask the court, and we'll incorporate our previous arguments, our previous motions to the court. You know, even the advocate recently stated, you know, we want the jurors to see, you know, the victim's family. You know, well, that you know, is an inconvenience. That's to try to change the balance of the scales here, to give the state an advantage on that. So, Judge, we incorporate our other arguments. I ask the court to not have a change of venue. I think with this hearing, and I think even in our previous hearings, this court took into account the difficulty in listed families and victims in its decision. I don't think the court overlooked that. I think the court took that into consideration, even referenced it in consideration. I don't believe there's any abuse of any discretion of the court, and I can't picture another case that would have a harder argument for a change of venue than this case.
Thank you very much. Do you want to make any record, Ms. Knappe?
If the court pleases, yes, I would like to. Your Honor, again, much like Mr. Hayes said, the court knows the state's position regarding change of venue. We trotted that out in the briefing, and we argued orally in front of this court, and the court, you know, considered all of that and made its decision regarding venue. However, I do believe that the victims' rights obviously were not fully represented at that time. While I did, in passing, make that comment about the hardship that would be not only to the victims, but to witnesses and et cetera, many of whom we did have to drive to court, as far as the witnesses. I do think this is new information. There's a reason why maybe the state shouldn't be representing the victims, because I'm not as educated and as proficient in all the victims' rights and the statutes and the case law surrounding their rights as Ms. Gall is. So I would ask the court, you know, we sincerely appreciate the opportunity for the victims to be fully heard today. And obviously she submitted statements on their behalf. But I would also ask the court to not only fully hear them, but to also fully consider this in effect, you know, making it a motion to reconsider its previous decision. And I recognize that the court will likely have to engage in somewhat of a balancing test or whatever, because the court has already found that the defendant's rights are implicated by not changing venue. So, you know, given the, you know, some of the constitutional sites, revised code sites, and case law sites that Ms. Gall has provided, you know, specifically that the rights of the victim are to be, I'm trying to find, protect the zealously as the, protected in a manner no less vigorous than the rights afforded to the accused. I think that kind of changes the landscape. Now again, what weight the court puts on it is obviously your discretion and the weight that you place on it. But I do think, given especially, of course, the state's position, that given that we used less than 1% of the jury pool last time for the county Pike, more distance from George's trial and Jake and Angela's things, but also recognizing that those facts are going to come into evidence in front of any jury. The fact that Jake pled guilty and what he has to say, that's going to be, as the court has recognized, key evidence in front of any jury that hears this. So whether or not a potential juror has heard tale of that, again, the court's admonishment that they, can only consider evidence that this court deems admissible into the courtroom and not those outside sources. Surely Jake and Angela's testimony are going to come into evidence. So, etc. Those also were not televised, in the first trial. So again, I think the potential damage, there's U.S. Supreme Court cases that says even pervasive adversive publicity does not necessarily parlay into a presumption of prejudice, right? So we still have the opinion that the court should go through those cases and try to do a searching and careful voir dire, especially because of the victim's rights that absolutely would be impacted, Your Honor, and adversely impacted to the point that some of them will not at all be able to attend hearings that they have a right to be present for. And there is a difference in televised, right? Because they can't converse with the prosecutor in between. They can't observe the jury. They can't observe the defendant. They can't hear statement of witnesses that elect not to be recorded and televised.
So does the prosecutor now, as a matter of law, have a duty to consider venue vis-a-vis victims? You had options with regard to venue. And in some cases, the options might be in a pattern of corrupt activity halfway across a state. So does that then put on the prosecutor, Mr. O'Brien's long-time career, to consider victims' availability to the courtroom when the prosecutor picks the venue? If you carry this out, is that what you're saying?
I think that would be a likely factor that you should consider. I mean, we certainly consider where the evidence is, where the witnesses are, because you want to be able to optimize your ability to effectively prosecute somebody.
Judge Hine, I don't know if you're aware of this or not, or whether you even care about this or not, but a lot of the witnesses in this case are also victims. So there's that.
Quality of the investigative agency, court facilities, all those things. No, it's all baked in there. Let's just admit it. 100%. We look for effectiveness. We look for convenience. How many times have you shopped judges don't answer out loud? Right? We all do it. We all know it goes on. It's not wrong. I'm just trying to decide if now you're taking on another legal burden as the state's representative to consider victims' rights when you pick the convenient venue where you have a much better chance to obtain a prosecution. We all get shocked. It's not wrong.
Yeah, I mean, again, how much weight that carries is at the end of the day, or certainly not the single deciding factor, right? So
I'm going to hear you say yes. You now have to consider victims' interests when you select venue. That's my conclusion of what I just heard you say.
Yeah.
Okay,
That's part of everything.
I don't know if I agree with that,
In this
but
case, the 3 of the 4 crime scenes are in Pike County, and at the time, we thought the 4th one was, and so it made most logical sense for Pike County, and that, thankfully, also aligned with the victims, because their family lived in Pike County, as most of them did, not all of them did.
given the oddity of the investigative resources available in Pike County at the time, it might have been better not to investigate this case here. That's just like
I need a moment, you guys. We all need a moment. Because that was, I've heard some things in my time, but this takes the cake. That last sentence.
What you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it.
It wasn't just Pike County that conducted the investigation. It was the Ohio State Police. The OBI, I believe is what they're called.
Rhetorical question.
Yeah, I mean, ultimately, we need to make, as prosecutor, I need to make sure that the judge is going to agree that venue is properly placed in whatever county we select.
But you don't lose the indictment, you just lose the venue. But it was awkward, to say the least, when the local investigative agency wasn't like appropriate to be involved because of like third-party anomalies. You weren't there, I just heard about it.
Right.
Like I look at most of the world from your chair. I only spent 3 years over there. I spent 14 years over there before I came over here for 27. All these perspectives are valid. Like, I'm not going to take on the duty to consider victims' rights if I'm a prosecutor when I select venue. Until you all sit over there and yell at me for not considering something that you wouldn't want to consider either.
But she did consider it, you jackass. She considered it because, again, one of the victims, I know TR, testified at George's trial. I know he did. I remember it. I covered the trial. Some of the victims are also fucking witnesses. So yeah, she would have taken that into consideration. And what you're suggesting is to put a even harder burden, more of a burden on Pike County, expense-wise. Because guess what? Regardless of where this trial ends up, Pike County is the one who pays for it. And the farther away you move it, the more expensive it becomes.
I think if you had a choice to not have this case in Pike County at the time and gave it a tactical evaluation, you might have considered going to a different agency in a different county to try to get all the help that you couldn't get here because of the anomaly. You did a fine job with what cards you were dealt. So like this is all argument, but people watch these arguments and want to know, like some adjoining prosecutor is probably glad you picked here.
Oh, for sure.
Yeah, no doubt about it. Like nobody
All the
asked.
counties that didn't get picked are happy.
Nobody asked for this. You involved other counties with regard to investigations far-flung to steer clear of the anomaly. If you thought you could have just landed in one county and not had to deal with the far-flung, that would have been even easier for you.
Yeah, I would say convenience to the prosecutor is probably the last thing to be considered, however.
That's a really good public statement to make.
It's true.
That's subjective. What else you got?
I would also note, Your Honor, that the first trial was live streamed, and yet the victim still chose to be here, which I think is a very good sign to the court. The value that they place on that right to be present is they did have the ability of the convenience of just sitting at their house and watching this, but they chose to be here. And as this court knows, that was an extremely long trial. From when the evidence starts, it was 2.5 months of testimony, not to mention the selection of the jury. So there's no question, Your Honor, even obviously Mr. Hayes agrees that they have a right to be present. I would agree that there is no substitute for being present. And while we appreciate the court's, thoughts on how to try to solve some of those issues, we submit that that's not sufficient to that they have this strong desire to be present, and that anything other than being able to be present. And I don't think that the court, I understand what the court's getting at. Well, how do I know this is going to be a financial impact and blah, 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 blah. Obviously they're not asking the court for court-appointed attorney or anything else that the court needs to make I don't think it takes much more than common sense, though, to believe everything they've written in here, right? That, one of the victims talks about, he would come for half days, which is you're able to do if you live in the same county as the case is happening. And so just the ability to get back and forth to court, drop kids off at the bus and be there when they get off the bus and all that stuff, obviously is doable if it's in Pike County and not doable if it's much farther away than Pike County. So again, Your Honor, given the fact that the state does not believe that there's a presumption of prejudice, which then reverts back to this court at least trying to see the jury, coupled with the interests of the victim, which at least the Constitution says should be pursued as vigorously as the rights of the defendant, I would ask this court to reconsider its decision on venue, but again, as Judge Corbin did, without prejudice, so that if it appears insurmountable, this court still has the ability to change it.
I'm not going to run around the room again to let everybody rebut, so I'm going to move on. And maybe the rest of it goes a lot faster. I mean, honestly, Ms. Gall, this is what I wanted to hear, because you're the specialist. I had lawyers ask me one time why I would grind them so hard when I would rule in their favor. And I told them after the fact that I grinded them really hard because I wanted to see how good their argument really was. So if you thought I was grinding you, it doesn't imply that I'm opposed. It doesn't imply anything. Like Ms. Canepa coming at me and me going back at it, that's how we get better, right?
Yes, Your Honor.
So don't misunderstand body language or vigor, whatever that means to you. On the list.
There's nothing to misunderstand. Your words were clear. Your tone was clear. We heard what you said.
List was also the question of severance. So we got to back up before that because there's a motion with regard to other acts, evidence, other acts. We argued this before. Memory serves me right. January we had discussion. I think I gave 14 days and 14 days, and Ms. Anstead, you made a compelling argument and gave me a list, if I remember right from my notes. But I didn't want to get to things if you still wanted to brief or be more specific, so I just want to close that book.
Thank you, Your Honor. We have researched the issue of severance, some case law on the issue. At this point in time, we're not planning on filing a motion for severance. There's a lot of interaction between that issue as well as 404B, issues that we'll continue to object and raise issue to as proceedings go along. But at this time, we're not anticipating filing that motion.
Okay. I kept your list from the last time where you sort of gave me, these would be appropriate. I'm going to still have that in the notes because I was the one asking how this plays out because you're asking me for a really nicely wrapped, tightly defined other acts decision.
The basis, and the basis that I provided at the January date was founded in the 404B philosophy and the rules under 404B, which we believe we'll be able to achieve our goals, our strategic goals, our legal goals through arguments under that rule and the case law under that rule. As far as filing the severance motion now, strategically and based on some research, not prepared to file that at this point in time.
Are you withdrawing the 404B motion?
No, Your Honor, we're not.
Okay, so I'm right back where I was. Because I brought up severance in the context of how do I give you this tightly defined, well-answered 404B decision. And it all depends on what the elements of the offenses are. You don't have to change your position. I'm just saying I'm back where I was when I brought this up.
And I don't intend to change the position, although this is an ongoing, it's a motion in limine, the 404B motion. So this is something that will be continued to be evaluated and argued as we go based on what evidence is being presented or attempted to be presented. So that conversation will continue, but with regard to a severance motion, not anticipating filing that.
Thank you very much. Mr. Bryan, you want to run this?
On that issue, Your Honor?
Yeah, on severance.
Well, I think as long as they haven't filed a motion and don't intend to file a motion, I have nothing to add.
I'm sorry, Mr. O'Brien. I don't understand this. Why in the actual F would the state take a position on a motion that isn't and hasn't been filed by the defense? Why are you even trying to have an argument about this? The defense doesn't intend to file a severance. So why do you need to hear from the prosecutor about how they feel about a severance that isn't even going to be filed? But you're interested in streamlining the process. Sure, Jan.
Yeah, but I asked for it, which I'm allowed to do. So, like criminal rule 14, the context is they want me to say what's admissible testimony with regard to other acts, and other acts immediately implicates what the charges are and relevance. So like they get hooked together. They're
At least my thought is, Judge, that other acts will come in whether or not there's a severance or not, because of part of the ongoing conspiracy that occurred, and therefore they would be admissible under 404B whether or not there's a severance.
okay. Now, am I supposed to let Ms. Gall argue on behalf of criminal rule 14?
I don't believe so, Your Honor.
Why not?
She doesn't represent the state.
Victim was not a party. That's an issue related to the issue of severance and/or 404B.
What do you think, Ms. Gall?
Your Honor, I am not educated on this motion to sever.
There wasn't questions whether you
It's
have
not
a.
something that I plan to weigh in on. I think that this doesn't implicate a victim's rights. Victims don't have a right to present evidence at trial or try the case.
Okay. Another run at it? Anybody?
What in the actual hell is happening here? What is going on?
Talk about scheduling, which we can do off the record. Because it's still set for May 30th. How about, just for my benefit, an update on where we are in the Court of Appeals?
Your Honor,
Mr. Collins?
may I?
We're still
Yeah.
on, right?
Yes.
Yes, yeah. We're still on this issue.
May it please the court,
Thank you.
Your Honor, I believe they picked the final oral hearing date of June the 12th. That was agreed to, I believe, by the government's appellate attorneys and our other co-counsel, Mr. Goddard. And I asked Mr. Goddard in terms of, in this type of appeal and this type of urgency, what he believed the result would be. He believes there'll be a decision within 30 or 60 days, but he qualified that by saying, however, I'm usually wrong on those things. So, but because of the nature of this appeal and the urgency of this case that the court has put on there, but yeah, the oral arguments are June the 12th. He believed the decision would be made within 30 to 60 days actually.
If I might address that, Your Honor,
Yeah.
I'll take the over on that estimate.
But then, the over, Your Honor, depending on them, what happens is if they rule in our favor, I'm sure they're going to appeal to the Supreme Court, vice versa, I'm not sure. But, and then again, with the victim's right advocate, who knows in terms of what gets appealed there. So, but just the basic information is June 12th of the oral arguments, and hopefully a decision will be within 60 days.
So this court doesn't make available documents online, so it's hard for me to snoop or actually find out what legal issues are going up. All the assignments of error start out the trial court erred. I'm good with that. It's just how we do it. So in the interest of not erring, I was trying to figure out whether anybody argued invited error, which always circles me back to the dilemma between where you sit and where I listen. So was that even briefed?
I don't believe so.
Briefed, you know?
I don't believe so, Your Honor.
Like, don't take this personally. Like, I like lawyers, maybe because I are one, and we think alike or we're trained alike, and I tend to believe what you say, but I'm getting hoisted on the Court of Appeals pewtered for doing what you said you were going to do, which I consider to be like invited error. Now, I'm okay if they don't consider that invited error. I'm 100% good with knowing what the Court of Appeals says because I follow what they say. But
Yeah, you sound like you're totes good with whatever the appeal says. That's why appellate courts have said. That's why you've brought it up 11 billion times in this hearing when it wasn't even germane to the conversation because you're totes not affected by it. I'm cool. Shut up. People who are fine don't announce that they're fine.
moving forward, I always have the ethical dilemma, professional dilemma, of whether anything.
Night,
I said
Deborah.
for the
Thanks
last
for being
hour
here,
is
babe.
anything I should believe. Nothing personal. We do it all the time. Our professional representations, our character, our ethics have meaning, hopefully value.
What are you asking them?
I heard you say, Ms. Anstead, that at the moment you don't have a motion to sever. And previously you answered my question about what could be a place to sever. And you're walking it back, but you could resurrect it later.
They don't have to sever if they don't want to. They decided that they were going to reserve argument for 404B, which is previous bad acts evidence. They don't have to, just because you brought up the idea of severing, and they've decided that that's not a good trial strategy for them. Now, what, are you big mad about that too? Well, why don't you just get glad in the same pants you got mad in, big baby?
I get motions in limine. You didn't do anything wrong. But if I'm supposed to be driving the bus and have some idea where we're supposed to be going, like, you don't have to like it, but I pick the direction. Because I get stuck with the trial court erred. If I drive the bus or if you drive the bus, it's always I erred. So like I'm more proactive, strike that, engage, no, attentive to where the bus ought to go. And I will continue to do that because in the end, we got to be ready.
No, you're not driving the bus. Let me tell you this is the worst analogy ever. Okay? The defense, they drive the bus for the defendant. The state, the prosecutors, they drive the bus for the state. Okay? You know what you are? If you're anything in this, you're a traffic cop guiding them. That's it. That's all. You can't make them have a trial strategy because you brought up severance. Stop it.
And Mr. O'Brien might be right on the over. Not a betting man, but that's a pretty prudent wager, perspective, or whatever. They got more than one case too. And so does most of the lawyers in the room. So I will wrestle with the professional dilemma of believing what I hear. Anything else on anybody's list?
Yeah, just two minor things to update the court. First is with regards to our client's hearing deficiency. Through his family member, we bought a device that we thought would cure that. It did not. I then met with an audiologist from Columbus, Ohio, explained what was going on, and then called the Pickaway County Jail, both the medical department as well as administration. They don't have someone who regularly will assess hearing, but through Ohio State has a program that goes into the prisons on a regular basis in some jails. And I was able to obtain an audiologist who will go in on May 7th, as long as I'm there, to have the hearing checked.
Fantastic.
Report an update.
What a relief. What a relief. I was so worried that Billy Wagner couldn't hear well. So worried. It was keeping me up at night. The fuck out of here. He hears just fine. You can see when he comes out of that little door in the courtroom that he's not missing hearing the chow bell.
It's probably about $6,000 to $8,000 for the hearing device that the audiologist thinks would probably be necessary along with a microphone. So I want to make the court aware of that. And then Pickaway County indicated that as long as one of the three of us was with them, that they would accommodate the best they could in that assessment. Normally, they send the people out to be assessed at a different place, but they didn't seem inclined to want to do that in this case. So I believe the Ohio State audiologist will go on May the 7th.
So you're saying it's an employee of Department of Rehabilitation and Corrections?
It's an employee associated with Ohio State, and they...
Ohio State University.
Yes, Ohio State University has a clinic that provides this service to county jails.
Great.
To prisons, I believe, as well. So they have some type of relationship with that. That's as far as I...
This pleases me so much because when the guilty verdict is read, I want Billy to be able to hear it, every single syllable.
Said that, yes, they've done that before, and they would not have a problem doing it.
Are you aware of this issue, Ms. Knapp?
Also,
I mean, Mr. Collins,
nobody gives a shit about Billy Wagner being able to hear. Neat Noodle says you aren't a very good bus driver, to be honest. Guess, well, this week he's driving a bus. Last month he was a train operator. Choo choo.
I brought it to us, our attention. He's been very upfront. And I know the court said you might make some inquiries. And I guess it's the responsibility of the jail to provide medical. I mean, the bottom line is, speaking of indigency, his family is not poor.
It's not.
Could be accused of being millionaires.
He is...
Family is not the test.
He is.
Well, carry this out, because now do I have to get an affidavit of indigency from the victim's family?
Well, only
No, I
when-
get what you're saying.
The only reason I said that is because Mr. Collins made a comment, I think, in his email that he couldn't find a family member that would finance this.
Yeah, no, I don't.
So, but-
His family's got nothing to do with it. They got no legal obligation.
I think when he's in custody, I think the jail is responsible.
Yeah, so here's my answer, because I did what I told you to do. Nobody that works in a jail thinks he's got a problem. No, so you can do what you want to do, and I'm happy you're proactive. Like, I totally like this. But at some point in time, the question's going to come down as like a convenience or a necessity, right? Like, from a practical standpoint, nobody there has ever experienced, charted any hearing deficiency. So in their world, they're a little skeptical.
I mean,
Understood, just for the court's background, from the...
listen, we all know how this came down. We were there when you asked the defendant, Billy Wagner, didn't say, huh, not one time. Anytime you talked to him, anytime that you directed a question at him, he didn't say, excuse me, didn't say, pardon me, he didn't say, huh, none of that happened. You, for whatever reason, out of the blue, just asked Mr. Wagner if he had a hearing problem. And suddenly, homeboy can't hear. Shut up.
We first met him, it's always been an issue on one side. He can't hear us, he had to turn and we had to talk to the patient. And then the second is to update the court, Your Honor, we had a very productive meeting at my office with Mr. O'Brien and Ms. Canepa. I think we've narrowed down potential stipulations and probably cut out 30 or 40 witnesses who might not be necessary. I would only ask, the government was going to provide us with those. We would like to try to get them in writing and then to make sure our client signs off on those. We are in the process of doing that as well, Your Honor, but that was productive in terms of, I think we cut out 30 or 40 witnesses, correct? Stipulations, right? So just update the court on that as well.
Music to my ears, or at least one ear. Anything else?
No, Your Honor.
Thank you. From the state, Ms. Gall, anything? Okay, so let's go off the record and find dates, scratch our heads. Thank you, Joe.
Yeah, they're off the record. That's it. All right, you guys. So that was the totally nonsensical hearing where nothing really got resolved. So that's all I got for you guys tonight. I want to thank you guys for being here. I'll be back at some point this weekend, probably on Sunday. I have moving to do tomorrow. I don't want to at all. All right. But I do want, okay, like I'm not jazzed about loading up a moving truck and bringing it all up, loading it and unloading it, and then having to bring it up a flight of stairs. No, I'm not jazzed about that. And if I was jazzed about that, there'd be something wrong with me. I don't know anybody that would be jazzed about that. But that being said, I'm very, very grateful that we were able to find a place that is in really close proximity to our to my daughter and her husband, and most importantly and especially my little granddaughter. So I'll be busy tomorrow, but on Sunday, I think that I want to do the aftermath of Lori, because she's given another interview, and this time now I will find a way to make this where there can't be a copyright claim. Okay. All right, you guys. And Cuff You says, loving this channel. I will be back. Well, we are glad to have you. I'm glad you're enjoying the channel. I appreciate that very much. All right. Last thing I'll say is, if you haven't done so, give your girl a thumbs up, and I'll talk to y'all later. Bye. Have a great rest of your night and weekend. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No militia.
Finish her!
Minutes later.
We all do a little match sometimes.